Thank you for the invitation. Another lawyer. I thank as well Hyun King, my associate, who worked on this presentation. So what are the challenges and the response to 3D printing? And I'll focus on IP issues, but you will see they are not the only ones that are important. I think that the challenges are more on the side of the business, although there are some IP or some legal challenges, clearly. And I think as well that the response should be more into development of right business models. I don't think that we have to change the law, in particular that we have to change IP laws to deal with 3D printing issues. So basically, what can we use as IP rights in relation to 3D printing? Well, I think we should first of all distinguish, and I will do it more into details, objects and designs. But basically, they can, at least the objects, can clearly be protected by, in principle, 3 different rights: copyright, design, and trademarks. But there are some issues. For instance, with trademarks, it's not easy because 3-dimensional trademarks have some constraints. For instance, if they have, like the Lego brick there, if the shape has a technical effect, it cannot be registered as a valid trademark. Other shapes, like the shape of those bunnies for chocolate bunnies, and I think we can print chocolate as well. There was no example there. That's unhappy. Otherwise, I think we could use it directly rather than the bones. Still now I don't need them, but. The bunnies were not considered as protected because they are not distinctive. But of course there are other shapes which can be protected by design, and typically shoes. There have been cases involving the Croc shoes, and there are machines dedicated to printing shoes. So design right might be involved, but I think in most of the cases it will be copyright. Copyright protects the shape, and we'll see under which conditions, the shape of things. So earrings, for instance, like this example, which is distributed, as you can see, under a Creative Commons license. That means that end user might be able to reproduce it using a 3D printing machine if they use it for their own private use. So basically, if we go a little bit more into details, and that becomes very legal, so probably a little bit boring for you, there are some conditions for IP protection that will be respected. For instance, with this earring we just saw, the dolphin earring, I think we have there an original form of expression which can be protected, so the 3D printable object can be protected. It might as well be eligible for design protection in the case we have a new appearance of a product with an individual character, and we could go on into discussing what does it mean, new with an individual character. I think that in the case we have a B2C segment, so it's a copy which is made by the consumer, then exception will apply. Exception to copyright, such as the private copying exception, which exists in the InfoSoc directive. It's the main directive on copyright in the EU. Where we have 2 exceptions, the one for private copying and as well the reprography exception of Article 5.2, which could apply. So there is no possibility to prohibit the making of a copy by an end user. But what we have in Europe, usually, at least on the continent, when there is a private copying exception, there is a system of levies. So I'm sure there is no collecting society claiming so far levies on 3D printers, at least that's what I think, but I might be wrong there. But we can see that in the future, because there are discussions in different countries on whether printers, 2D printers, should be levied or not, falling under the private copying exception, which allows for fair compensation in exchange for the private copies. There might be a discussion whether it falls under 5.2b, 5.2a, with some implications, because the scope of the levy might be different. Other exceptions might apply, like the exception for repair, which exists as well in the InfoSoc directive. So those are exceptions for copyright. And then we have more or less the same for design with the personal use exception. So basically, there are exceptions against favoring, the end users if they use 3D printing for their own use. Now, let's move to what appears more important, I think, and that is the challenge relating to the protection of digital designs files and 3D software, where there is a real business, and there we are more into B2B segment in this market. So basically, digital blueprints, which are important for 3D printing, can be protected, be original. There might be some problems if the shape is completely dictated by a technical function, but we saw an example of very nice, chair, for instance. That is not completely dictated, I think, at first sight, completely dictated by the function. So it can be protected. Of course, I'm not speaking about the object here, but I'm speaking about the blueprint, the design for this object. There are as well companies involved in the design of 3D software, and my understanding of Materialize is that they are as well on that segment. Of course, when you have digital files, and here we are dealing with digital files, there are some risks. There are risks of piracy. There are as well different models. There is the standard proprietary model based on IP, on copyright mainly. But some companies might adopt an open source approach, and even a company like Autodesk, which is mainly a proprietary software company, now is pushing through its Spark platform for some kind of machine which is open software and open hardware. So probably they want to get some money out of what they sell otherwise, CAD systems or other services. But they are competing with the standard player into the 3D printer field like 3D systems. So there are exceptions applying here as well, and there are special exceptions in the case of software, like the exceptions for reverse engineering, or there is a special rule for exhaustion that we might discuss as well. And of course, as we are dealing with digital files, we have the online piracy problem that doesn't exist as such with the objects, the material objects I was discussing with the previous slide. And there, of course, the solutions are the same with other digital files and digital works. There is a possibility to use DRMs, which might apply here to the blueprints, to the designs. And there might even be patents on the DRM solutions for 3D printing, which might be solutions, technical solutions, which are themselves protected by the law, because DRMs are protected under the InfoSoc directive against the convention. As we might have online platforms distributing those either blueprints or 3D software, there would be a possibility, like for more standardized digital works, I mean music files or movie files, there might be a possibility to go against those platforms using, there are some legal bases for that. I don't want to go into details. I think the challenge basically is a little bit the same as the one we had for other types of works. Digitization was the technology which disrupted the content industry, which of course led to the appearance of many pirated intermediaries, which themselves prompted new business models. So I think for 3D printing, we are still waiting for the new business model, the new Spotify or the new iTunes or Netflix model that might be appearing. And it's not that easy, of course, because you have to fight the culture of free. And there will be some piracy of 3D designs, for instance. There is already. Probably the only possibility is to involve the consumers, I think. And we know the possibility for phone makers in the future to have the possibility for the owners of their phone just to print a new cover. But that will probably not be enough. You need to give more to the consumers. They should be able to customize the cover, for instance, and they should be involved in just making the product more interesting. And I think that's a challenge for companies, and Lego, for instance, which is directly challenged by 3D printing, of course, has been already in the past, and they are doing it now because they want to provide to their customers 3D printing tools. But you have to involve your customers in an approach with this open innovation, whatever that means, and it means different things. So I think on the IP field, there is probably not much to do at the legislative side. There are maybe some transactional arrangement to develop. There is probably more issues and concerns, and that's what I just heard by the previous speaker, with other regulation, like the medical device regulation and other, like the Toy Safety Directive or the General Product Safety Directive. And I'm not an expert on all those sources, but I think there we have more challenge than in the IP sector as such. Standardization, you see some example here of standardization bodies which are creating new standards in the field of 3D printing. I think standardization is another aspect of the market which will change the competition and the way companies are conceiving their products, their market. Standardization might favor some players, play to the detriment of others. There might even be some IP-related issue with standardization if there is some form of hold-up of the standardization process by some players. So to conclude, do we need legislative solution in order to force 3D printing business? I don't think so, and I don't think that the IP laws, especially at EU level, should be changed. There will be incremental changes in the application of the existing framework, that's clear. And in order to fight, for instance, 3D printing piracy involving those blueprints, those designs, some new tools might be necessary. There might be some adjustments as well through private copying levies, and I'm not sure that everybody wants to have them in the field of 3D printing, because that means that collective management societies will be involved, and how do you then distribute the money collected onto 3D machines? I'm not sure we want to go that way. That might create other issues, but I see the possibility and the claims coming from some collecting societies. I think in general we should have a framework that supports new legitimate licensing practices, and of course the enforcement rules that we have in Europe in the enforcement 2004/48 directive might be helpful. So we have already the rules. And we should as well coordinate with possible regulatory development outside the EU. Thank you very much.